Distinguished senators, that everything we did in the past remain in the past. Everything we did in the closed sessions remain consultations. What we do now is what will go into the votes and proceedings. Am I right? So the Electoral Bill 2025 Yes?
Proceedings. Recall, Mr. President.
I think that everything we did in the votes and proceedings, we only carried out closed door sessions.
Yeah, so we...
The correct place to bring up anything you want to amend. So an act to repeal the Electoral Act 2022 and to enact the Electoral Bill 2025 and for other matters related thereto. SB 903. Now, we are aware that our colleagues in the House of Representatives are undertaking the same exercise. So I have already, in consultation with the leadership, we have set up a conference committee of the Senate. So immediately we finish this exercise, they will team up with their colleagues in the House of Representatives to tidy up for Mr. President's assent. Repeal and Re-Endowment Bill 2026, SB 903, clause by clause considerations. Clause 1. Those in support that clause 1 remains part of the bill say aye. Those against say nay. The ayes have it. Clause 2, 3, 4, 5, 6, 7, 8, 9, and 10. Those in support of clauses 2 to 10 remain part of the bill say aye. Those against say nay. The ayes have it. Clause 10, yes.
Clause 10, Your Excellency. My name is Senator Asuquo Ekpenyong. Under Clause 10, on page 9, continuous registration. Each applicant for registration under the system shall appear in person with a birth certificate, Nigerian passport, NIN, and some other documents. I have an observation here with regards to the coverage of NIMC and the NIN numbers available in rural areas. And if this might not be...
all Nigerians have NIN numbers. So.
Yes, sir. That might be disenfranchising.
Huh? No, not all.
Did they say any? Okay, with any. I stand corrected. It's any, not all.
Let me explain.
Any, I understand.
Let me explain. Because not all Nigerians have NIN numbers. That's why they said any.
Withdrawn. Okay. It's in order. Retain.
Okay. Maybe he traveled. Okay. So now listen. Clause 11, Clause 12. I hope you are looking. Clause 13. Clause 14. Clause 13.
Thank you, Mr. President. In Clause 18 of the bill, there is a proviso in 18 subsection 1. Oh, I thought 18.
Aye. Those against say nay. The ayes have it. So 11 to 17. Now, clause 18, yes?
Thank you, Mr. President. So, in clause 18, subclause 1, which is provided that nothing in this clause shall prevent the owner of such card from printing a downloadable copy. I think it's susceptible to manipulation and fraud and should be removed. That is the proviso that has just been inserted in clause 18, subclause 1. Yes, of the bill. There's a proviso which says, provided that nothing in this clause, when you
Am
talk
I
about
having a
replacement
different
of
bill?
permanent voters card,
What page?
page 15, sir.
Eh?
Page 15, the bill.
15. Yes, page 15. Yes. Power to issue.
After 18.1, which says, provided that nothing in this clause shall prevent the owner of such card from printing a downloadable copy. And I'm moving that be deleted because it's open to fraud and manipulation. What are you reading?
Nee. Please use the one that was provided today. No, use the one that was circulated today, and then whatever objection we can amend it now. Whatever you want, we can amend now if we all agree. But use the one that we are all using.
The one that was given today.
Okay, let me explain.
What we have, what was done today or distributed today reflects what was discussed in closed session.
You are not hearing me. I'm saying that what we discussed in closed session can only be authenticated by what we do now.
Yes, sir.
So if there is any objection, look at it. And then nothing is there, then bring it up so that we debate.
With respect to my colleagues, please, discuss it.
Sorry.
There are two documents before me. There is the bill, and this is what reflects yesterday.
What you have there is a bill.
So what I'm saying,
what we are using is a bill. We are working on the bill, but the reality is that. But I'm saying, use that guide to guide yourself. So tell us what you want. Read what you have, and let us see what we have.
What I am saying, sir, is that. So I am reading, quote and unquote, the report.
It's not a report.
What we have
it's a
now
bill.
Is there is only one clause 18.1. There is no proviso. So I move that it be so adopted. There is no proviso now.
Was that we should not allow anybody to go to a business center and reprint any card. So what we are working on now, go ahead and then put it the way you want it so that we can all go take it.
The proviso be deleted entirely. If that proviso is now deleted, it will read as it is this document that was distributed yesterday.
What you should tell us is that we agreed to retain what was in the original act. Am I right? To avoid people going to reprint.
What was in the 2020 act is what was agreed to be retained.
And that is what is retained. It's retained.
Yes. Thank you, Mr. President.
Are you now?
I now understand, sir.
Okay. So you're. Clause 19. Those in support say aye. Those against say nay. The ayes have it. Clause 20, 21. Those in support of clauses 20 and 21 say aye. Those against say nay. The ayes have it. Clause 22. Asuquo.
Yes, sir. Observation on section 22. The clause 22 on page 19. The offenses,
22 of
the offenses as written here, as written in the proposed bill, a person who is in unlawful possession of any voter's card, whether issued in the name of any voter or not, sells or attempts to sell or offers to sell any voter's card, whether issued in the name of the voter or not, commits an offense.
it's
and
on
is liable.
page what? Page what?
Page 19, clause 22. ABC. And the summary there, commits an offense and is liable on conviction to a fine of not less than 5 million or imprisonment of not less than 2 years or both, and shall not be eligible to stand for election in Nigeria for a period of at least 10 years.
No. Please. It's too rigid.
And extremely punitive.
Huh? Too punitive, too rigid, and it doesn't even tell
the fines
how
are
you came by the
imprisonment.
voter's card.
The 2022 Act states on conviction a fine of not more than 500,000 or imprisonment not more than 2 years or both. While I agree that the fine may be increased to be more commensurate,
What you are referring to? The original act was talking about a fine of 500,000. No, it says, or imprisonment not more than 2 years. We can't do that.
Increase the penalty to 5 million and retain it the way it was. Put the vote and then we move. Remove
2 years assessment. If you have any doubt about any clause, we have committee members, call them for the explanation. Call for an explanation. One. Secondly, we had an executive session yesterday on most of these clauses.
Senator Ningi,
Mr. President,
it is not how much you shout that we'll hear.
I'm not shouting.
Okay, so take
That
it
is
easy.
how I am. That is how I am, because this is a procedure.
But take it easy. Let me explain the procedure. We are here to do amendment. And what we amend now, of all those consultations, all those retreats in Lagos, all those closed door sessions and everything. So what we do now is what is final. So, DSP, your proposal.
We retain what is in the Eastern Act, but increase the penalty to 5 million.
Sani Musa representing Niger East. I stand to second the motion as moved by the DSP that we increase the fine to 5 million and then leave it retained as the 2022. Yes.
Well, the people say aye. Aye. Those against say nay. The ayes have it. So, that was on page 19. So, okay, on page 20, anything? Is there anything on page 20? Those in support of page 20 say aye. Those against say nay. The ayes have it. Then, so we move to clause 24. Conduct and postponement of election in emergency. Is there any change? No, the reason I'm saying that, I'm asking, come, let me show you something. So clause 24 as amended. Those in support say aye. Those against say nay. The ayes have it. What clause are you? What clause? Clause what? We are past that. We are past that. We are past that. Just follow us gently. This is lawmaking. It has its own procedures. Anything that we have passed, on our next sitting, if you are not satisfied, you come by way of motion on rescission. And then you now circulate it to all members and explain why you want that to be changed.
Already in January, and elections are going to be, we cannot meet, if it is 360 days, there's no way we can meet that requirement. That's why I proposed an amendment to 180 days for us to meet that requirement. Because as it is now, we have not even passed the Electoral Act. It has to go to the president for amendment and what have you, then notice. We cannot meet the 360 days.
If you find it in the constitution, we also go and deal with it.
If we are doing it today, we'll meet.
Yes. If in 180 days we are going to meet, but 360 days we are not going to meet, even if it is constitutional, constitutional requirement. We still have to deal with amendment of the constitution, which we are not going to meet, and we have not seen it in the constitution for now.
Me.
Yes, sir.
I'm saying that if it is 1 year before the election, and we hold election in March,
yes,
we will meet the 1 year. Or we hold election in February.
Yes.
If this is concluded today, and then the harmonization concludes its work in a few days and the president signs this month, then we'll meet it. So it's not a problem. But let's find out if it is not there, then we amend it to 180 days.
Let us work in the side of caution, with abundance of caution, so that with first 180 days, we can meet it. Let us work with abundance of caution. Because as it is now, we don't know what is going to happen. So we work on the abundance of caution and then fast 180 days, so long as it is not in the provision of the Constitution.
Yes, Osho.
Thank you, Mr. President. I think the Chief Whip need to bear in mind that your explanation is more feasible than his suggestion that will require amendment of the Constitution that has to go across the two-thirds of the states of the Federation. Your explanation is simple. If this thing is done within February and notice the President signed, election can still take place in March, and you do not require a constitutional amendment. That is absolutely safe. There is no uncertainty whatsoever. So, my dear brother, Leonard Rankin, the explanation of the Senate President is compelling and is lucid.
Thank you. That's my opinion. But I'm prepared to allow us to come back to that if Senator Alero or Abdullahi finds it. You know, but Adegbomire, is it there? Did you?
Thank you, Mr. President.
The clerk of the Senate.
I think that I must own up to the error. I think what at the date of the election. Yes, sir. It says 150 days before the end of the tenure. I can read that. That is. Just hold on. Let me use, for example, section 76. Time of election to the National Assembly.
I have it. Go on.
I'm reading the Constitution now.
Read it.
I just want to use an example of the National Assembly. It says,
from the Constitution.
Elections to each house of the National Assembly shall be held on a date to be appointed by the independent National Electoral Commission in accordance with the Electoral Act. Subsection 2. The date mentioned in subsection 1 of this section shall not be earlier than 150 days and not later than 30 days before the date on which the House stands dissolved, or where the election is to fill a vacancy occurring more than 90 days before such date, not later than 30 days after the vacancy. But this speaks to date of election. The section which has been brought to our attention talks about notice of election, and I'm saying there are two different things.
What I've seen here, section 76, says elections to each house of the National Assembly shall be held 76.2 says the date mentioned in subsection 1 of this section shall not be earlier than 60 days.
150, sir.
Do we have two constitutions? Huh? The date mentioned in subsection 1 of this section shall not be earlier than 150 days and not later than 30 days and not later than 30 days before or where the election is to fill a vacancy occurring more than 90 days before such date and not later than 30 days after the vacancy occurred. In other words, after a vacancy occurs, not less than 30 days, we should call for a by-election. Is the 150? Is the 150 days?
Yes. The issue was that in the Constitution before it was 360 days.
There is no longer
in the last constitutional amendment, it was removed from the Constitution to the Electoral Act. And this section 76 is now the prevailing constitutional provision, and which you have correctly read out. That this, the date mentioned in subsection 1.
Clark, what you gave me now, is that the Constitution?
Yes,
so the Constitution says 150.
This is the Constitution, sir. What you rightly read now.
The Constitution says 150.
The Constitution says not later 150 days. Not earlier than 150 days before the time when the dissolution of the National Assembly is supposed to hold. So it means that it cannot be conducted, it should be conducted not later, between 150 and 130. And 30 days. That means you can extend the election to be concluded 30 days to the day of the inauguration of the National Assembly. But you cannot do it earlier than 150 days to that date when, under normal circumstances, the National Assembly will be dissolved. So 150 days from the date that the National Assembly's mandate expires, you can still conduct an election. But you can also do the election 30 days before the expiration of the term of office of members of the National Assembly. This is the constitutional position, sir.
Mr. Chairman, if I may again try and break this down. So, Senator Izunazo, please, just a minute, sir. Senator Izunazo drew our attention to clause 28. Clause 28, let us read the heading of clause 28. It says, notice of election. Notice of election. The constitutional requirement, section 76 says, time of election. There are two different things. Two different things. This is the constitutional, which talks about time of the election. In other words, the date on which the election is to be held. So, section 28 says, give notice when that election will be held. Two different things. Section 28 is not covered by the Constitution, so we can amend it if we want to.
Okay, in that case, Senator Izunazo, second the motion.
Thank you very much, Mr. President. From what the senior advocate have explained, from what he has explained, I'm just agreeing with him, and I'm also agreeing with Senator Mongonu. No, I will not second it like that because the number of times you have proposed will not be enough, because we are talking about time for INEC to announce when the election will hold. So they require more time, but not. Let me explain. No, not about seconding. Let me explain, sir.
Wait,
so,
don't second. DSP.
No, sir. Let me explain it. After the explanation, then we can continue.
Are you working in INEC?
Huh?
Are you working in INEC?
Sir?
Are you working in INEC? If INEC gets prepared a year before or 2 years before, but gives notice of an election 180 days before the election, is there anything wrong with that?
No, sir. Let me explain. Just hear me out for 1 second.
Huh?
So, no. Sir,
no, Senator Tony, please tell us, is there anything wrong with that?
There's nothing wrong with it.
No, use your mic.
So I second the motion.
No, use your mic. Use your mic.
Mr. President, I'm of the opinion.
Yes. But we want to change the notice to 180 days. Tony, are you aware that 360 days is 1 year? And so we have only 4 years. Where do you have your own from?
Listen. Section 29, page 27.
Listen. Distinguish.
Yes, sir.
You came late yesterday.
Please allow me to finish, sir.
Did you come late yesterday?
Yes, I did, but please let me...
So read what we have.
Chairman, listen now. I know now. Let me finish. Please let me learn, sir.
I'm not denying you your right, your privilege, but I want you to note that we had looked at this as a Senate, and we are past that stage. And what the stage we have is 120 days.
Mr. Chairman.
Use your mic. If 180 days was provided for when it was noticed at 360 days, it stands to reason that that notice and the deadline too should be halved to 90 days. That is what I have tried to learn.
Okay,
and then it can be put up for debate.
Move your motion that we
my
move,
motion.
Your motion is that we reduce this
from
180 days. No, because the 120 days earlier agreed by us was in closed session.
Yes, sir.
So we moved this from 180 days to what?
To 90 days.
To 90 days. Any seconder? Yes, the Senator Abdul Ningi.
Thank you, Mr. President. I stand to support the motion. I think that it only makes mathematical reasoning. That where you have reduced the length of notice, then it's also important that you limit the length of the publication of candidates. So I so second, sir.
Distinguished colleagues, the motion has been moved and seconded. General reduction in the notice of the intention to conduct election to 180 days, that this notice, that the submission, what do you call it?
The deadline for submission.
Submission of lists of candidates and the affidavits by political parties should now be reduced to 90 days. Yes, it should be done within 90 days so that it will help INEC. Those in support say aye. Aye. Those against say nay. The ayes have it. So, clerk, note, that has now been reduced to 90 days. section
Clause 29.
Mr. President,
yes, there's a
29-7.
29.7. Let me read for you. What was there before? I don't know, but what we propose is this. Notwithstanding the provisions of Section 6 or subclause 6, where the election has been held, the court shall direct the Commission to conduct a rerun election among the candidates that contested the subject election, save the candidate and the party so disqualified. That means as except. It's correct. What do you mean?
Saved is wrong.
No, this is correct.
No.
This is correct. The word there is SERVED. It's not to save the. No, it's correct.
The word is.
But to make it elegant, you can say except. You can use the word except so that.
Observation.
So that.
Observation.
You can use the word except. Yes. I think we should use except so that it will be clearer.
No.
Except, right? Except.
Chairman.
Those in support that we proceed
Chairman.
with that clause by using the word except
Chairman.
for clarity. So those in support that we use the word except the candidate and the party so disqualified. Except the candidate and the party so disqualified, just to avoid confusion and legal lacuna. Those in support say aye. Aye. Those against say nay. The ayes have it. So we go to Clause 30. Those in support that clause 30 remain as amended, say aye. Those against say nay. The ayes have it. Clause 31. Clause 31, those in support that clause 31 remains as it is, say aye. Those against say nay. The ayes have it. Clause 32. Yes, amendment clause 32. Yes, proceed.
Well, in view of the fact that we have reduced the number of their candidates, so we have no choice now than to reduce this to 60 days. He said the commission shall at least 150 days before the day of election publish by displaying or causing to display.
Sorry, what page are you reading? Senator Andubweze.
Thank you, sir.
So, are you saying that my name cannot be Agubweze?
At present.
Anyway,
no.
go on.
My name is Senator Andubweze Patrick C. I stand to second the motion as ably moved by Senator Isnaso of Imo West.
Those in support say aye. Those against say nay. The ayes have it. That is on clause 32.1. Any other observation? Clause 33. Clause 34. Clause 35. Clause 36. Clause 37, 38. Those in support that those clauses and the amendment form part of the bill, say aye. Those against say nay. The ayes have it. Clause 38. Asuquo, are you there? Clause 38. Clause 39. Clause 40. Those in support that the amendments enshrined therein form part of the bill, say aye. Those against say nay. The ayes have it. 41, 42. Yes.
My name is Mohamed Tahir Monguno. I represent Borno North Senatorial District. Mr. President, distinguished senators, I am craving for the indulgence of the Senate to consider the existing act, the whole of the existing act, in adopting this provision, and which includes reduction of the period from 60 days proposed by this committee to the earlier existing days of 20 days under the already existing law, in view of the amendment that we have subsequently done. From 20 days proposed to, from 60 days proposed to the existing 20 days in the existing act. Yes, from 60 days to 20 days in the existing act. The committee proposed 60 days. But in the existing act is 20 days. Section 42, subsection 3. Yes. 42, subsection 3.
36.
Forty-two subsection 3 is in page 36. I move for a motion to that effect, sir. 42 subsection 3.
Please, those in support that we retain what is in the original act, say aye. Those against, say nay. The ayes have it. So, Secretary, take notes. 43, clause 43. Polling agents. 43 to 43, 44, 45, 46, 47. Okay, so 43 to 46, those in support that what is here be embellished in the bill, say aye. Those against say nay. The ayes have it.
This has to do with accreditation. This is clause 47 on page 39. Accreditation of voters and voting. What we have in the Electoral Act 2022, a person intending to vote in an election shall present himself with his voter's card to a presiding officer for accreditation at the polling unit in the constituency in which his name is registered. To vote, the presiding officer shall use a smart card reader, that's Electoral Act 2022, or any other technological device that may be prescribed by the Commission for accreditation of votes to verify, confirm, or authenticate the particulars of the intending voters in the manner prescribed by the Commission. Number 3, where a smart card reader or any other technological device deployed for accreditation of voter fails to function in any unit and a fresh card reader or technological device is not deployed, the election in that unit shall be cancelled and another election shall be scheduled within 24 hours if the Commission is satisfied with the results of the election in that polling unit will substantially affect the final result of the whole election and declaration of a winner in the constituency concerned. Mr. President, distinguished colleagues, I'd like to propose a motion that we retain that 2022 version while redacting the use of smart card reader to provide for a bimodal voter accreditation system, that's BVAS. Do you understand what? Proposal brings in the downloadable voter card with unique.
No, we said no. That is not allowed.
It's not here. It's not here under the retained. It's not there. That's why I'm highlighting.
No, we've not accepted downloadable.
It's here under this, and it's stated there as retained.
Where?
No, clause 47, verse or page 39. Accreditation of voters under the proposed bill, which has been retained. A person intending to vote in an election shall present himself to a presiding officer for accreditation at the PU in the constituency in which his name is registered and shall provide any of the following forms of identification: an electronically generated voter identification, including a downloadable voter card with a unique QR code, or any. But
we said it should be removed.
That's what I'm saying. So we should basically retain what the Electoral Act 2022 says.
So propose that we delete this and.
I'm seconding his motion to the extent that what we had before should be retained, but there should be the BVAS should be replaced because BVAS is okay. We should allow the BVAS to stay. BVAS is okay. I say second. We retain.
Well, smart card.
Yeah, but BVAS is more.
So explain. If BVAS is better, so you have to come by way of
under the Electoral Act.
No, you have to come by way of a motion to amend that we should have
use BVAS now.
Mr. Chairman,
will BVAS.
In the 2022 Electoral Act, they provided for spreading it to state BVAS.
No, I'm saying that by the time it's BVAS, not electronic.
Or any other technology. Okay.
BVAS not electronic.
No. We are saying we are going back to 2020.
I'm saying it's BVAS not electronic. Yes. Because you are saying smart card or any electronic means. So outrightly, let us say BVAS. Okay. Use your mic. Use your mic. Use your mic. Use your mic.
Section clause 10. Let's look at clause 10. 10, clause 10 here. The voter identification, what they bring is Nigerian birth certificate, Nigerian passport, and national identification card. So all we need to do to conform to the removal of downloadable thing that we say we didn't agree with. If you cancel,
the motion has been moved by Asuquo and seconded by the Deputy Senate President that we retain section clause 47 with a minor amendment from smart card to beavers.
Put the question. Put the question. Put the question.
Okay. Okay, so, but this sort of smart card, we put beavers. Okay. So 47A is to be deleted, and then we just put beavers. Yes.
Central, I propose that we retain the amendment with the deletion of the downloadable voter card, which is 47(1) subsection A. So I propose that we retain the amendment, but we only, with the deletion of this particular part, which is the downloadable voters card with a unique QR code as contained in section 47.
She made a proposal. She made a motion. I'm saying any seconder to that motion? Yes.
Mr. Chairman,
downloadable.
Distinguished colleagues, I'm Senator Abbas, Adams Central. I second the motion as moved by Senator Tasha Poti.
Okay, the motion is that we should delete download. So we should delete download. So we accept. So they shall propose that we remove the word downloadable in that clause. Those in support that downloadable we remove, say aye. Aye. Those against say nay. The ayes have it. So what again do you observe? Senator Odende, do you observe any other things?
It should be the PVC. Because the following form of identification, if you remove A, which is a form of identification, for the purpose of election, it should be PVC. Not any other means. It should be your PVC that should use to identify yourself.
No, but that
currently, since PVC was introduced, it has been retained. Now, to leave it open in the manner it is worded, such as B, any other form of identification as may be prescribed in clause 10. No any other form.
No, we said
it
PVC.
It has to be PVC because any other form will be open to abuse.
That's correct.
Yes, sir.
Senator Plan.
Sir, if you look at the extant law, the extant law specify what a voter will present before a presiding officer. And the extant law says that you first of all show your voter's card. After voter's card, you go to number 2. No, look at it, sir. Look at this, sir. That's PVC.
Yeah.
You shouldn't have voter's card. The PVC is a voter's card. So, sir, I still feel yeah, Sir. I still feel a person. What do you mean? It's PVC. I'm talking about PVC 147.
Let me specific PVC.
Okay. Yes, sir. Yes, sir. Yeah. Yes, sir. Section. Yeah. Sir. Sir, section. Section 47.
Clause
subsection
what?
1, sir.
Clause
Just
what?
listen to me, sir.
Clause what?
Sir?
Which clause?
Section 47, subsection.
Which clause?
Okay.
Okay, section
Clause
47.
Subsection 1 is a form of identity. And the form of identity is that the voter should present voter's card.
Yes.
It's only when you present the voter's card, then you go to subsection 2. And therefore, if we remove A and B, it is like the voter will only come and stand before the presiding officer. The presiding officer, if he appears before the presiding officer, he should present his voter's card.
That is what we have accepted.
It's okay. It's okay.
What we are saying is that first version, we are now sticking with the Electoral Act of 2022, but with beavers.
Yes.
What the second motion said was to remove Section A, Section 1A and B, which is essentially the same section as the Electoral Act 2022, but with beavers. So it's in order. No, listen to. So, what they are saying is that that we should stick to the Electoral Act 2022 and just change smart card reader to bimodal voter registration. Beavers.
Yes. Dr.
Kaila, representing Bauchi North. Sir, there are two committees here. A committee sat and came up with the report. Another committee sat, which is the ad hoc committee. I think the right thing to do is to ask the chairman of the committee to explain to us why they put those things, or they should explain to us why they arrived at that decision. Because this is not something that we did like that just from the blue.
Thank you. But let me say, for the voter, we have agreed that he will present himself with a PVC. Am I right? PVC. Those in support of beavers and PVC say aye. Those against say nay. The ayes have it. Senator Wadada. If we ask you what you shouted nay for, will you tell? The Secretariat, take notes. So clause 48. Those in support of retention of clause 48.
He keeps quiet, then goes to his chambers and decides that I have looked at it, no, you did not win, without affording the parties the opportunity to challenge such an evidence.
To the document.
So for me,
so the
it
parties
should even
must
go.
tender the document.
There is no need for it. Once it goes, the rules of evidence will come into play, which means when you put a document down, you must speak to it. Simple. It should actually be expunged.
Senator Odende.
So I move that section 142 be deleted. I so move.
No, use your.
Well, I think instead of deleting it, why not?
No, let's just delete.
When you delete,
let the court.
The principles of evidence
thank you.
Because there is a Supreme Court judgment.
I'm not a lawyer.
The
I
Supreme
say
Court, in view of the Supreme Court decision on the subject, where section 42 is proposed for deletion. Those in support say aye. Those against say nay. The ayes have it. So you succeeded. Please delete section 142. 143 to 150. What about what? Huh? We have finished. We have deleted that section. Those who support that 143 to 150 form part of the bill say aye. Those against say nay. The ayes have it. Those in support that clause 151, 151 to 153 form part of the bill say aye. Those against say nay. The ayes have it. Specifically, (144), 154, 155, 156, 157, that they form part of the bill say aye. Those against say no. Say nay. The ayes have it. The citation clause 158, those in support that this form part of the bill say aye. Those against say nay. The ayes have it. Specifically, the schedules on pages 157 and pages all the way to pages 232, that they form part of the bill say aye. Those against say nay. The ayes have it. Page 240, those in support that this form part of the bill say aye. Those against say nay. The ayes have it. Title on page 1 that this form part of the bill say aye. Those against say nay. The ayes have it. Leader of the Senate.
As chairman, very distinguished senators of the Federal Republic of Nigeria, I rise to move that the Senate do now revert to plenary to enable the chairman report progress. I so move.
Mr. President, sitting as chair, I second the motion that the Senate reverts to plenary. I so second.
Distinguished colleagues, seconded. Those in support that the Senate reverts to plenary for the chairman to report progress, say aye. And those against say nay. The ayes have it. Distinguished colleagues, the Senate in the Committee of the Whole considered the report of the Committee on Electoral Matters on the Electoral Act 2022 Repeal and Reenactment Bill 2026 and approved as follows. Number of clauses, clauses 1 to 21 as recommended. Clauses 22 to 27 as recommended. No, sorry, clause 22 as amended. Clauses 23 to 27 as recommended. Clauses 28 to 29 as amended. Clauses 30 to 31 as recommended. Clause 32 as amended. Clauses 33 to 42 as recommended. Specifically, clause 42 as amended. Clauses 43 to 46 as recommended. Clause 47 as amended. Clauses 48 to 59 as recommended. Clause 60 as amended. Clauses 61. Clause 61 as recommended. Clause 62 as amended. Clauses 63 to 76 as recommended. Clause 77 as amended. Clauses 78 to 85 as recommended. Clause 86 as amended. Clauses 87 to 141 as recommended. Clause 142 deleted. Clauses 143 to 155 as recommended. Interpretation clause. Clause 156 as recommended. Interpretation clause 157 as recommended. Short title clause 158 as recommended. Schedule first schedule as recommended. Second schedule as recommended. Explanatory memorandum as recommended. Long title as amended. Is this a true reflection of what transpired in the committee of the whole?
Very distinguished colleagues, I rise to move that the bill be now read the third time. I so move.
Mr. President, I second the motion that the bill be read a third time. I so second.
The motion has been moved and seconded that this bill be now read a third time. Those in support say aye. Those against say nay. The ayes have it. Clerk of the Senate.
A bill for an act to repeal the Electoral Act number 13, 2022 and enact the Electoral Bill 2026 to regulate the conduct of federal, state, and area councils in the Federal Capital Territory elections and for related matters 2026 SB 903, third reading.
Bill for an act to repeal the Electoral Act number 13, 2022 and to enact the Electoral Bill 2026 to regulate the conduct of the federal, state, and area council elections in the Federal Capital Territory and for other related matters 2026, third reading taken. Distinguished colleagues, a bill for an act to repeal the Electoral Act number 13 of 2022 and to enact the Electoral Bill 2026 to regulate the conduct of the federal and state elections and also area council elections in the Federal Capital Territory and for related matters 2026, third reading taken and passed. I want to thank all of you. First, let me thank the chairman and members of this electoral of the Senate Committee on Electoral Matters for this wonderful exercise. Distinguished Senator Ningi Adegbomire, Senior Advocate of Nigeria. I salute you. I thank you for your dexterity, hard work, your patriotism, and your love for your country. I also commend all the members of the Senate Committee on Electoral Matters and commend all distinguished senators for their contributions, and particularly for the interest shown. It means that your DNA actually shows elections. Because you can imagine, Senator Ningi, this is almost 7 p.m. No senator has eaten, no senator has left, except those who went to ease themselves and returned. The chamber is still very full. In normal instances, Senator Abdullahi, I would have thought that people like our elder statesman, Senator Farahonsi, would have gone home to rest by 4 o'clock, but he's still here. That shows he wants to be sure of the next election and the form it will take. So I must say that I'm very glad, and I thank all of you. Senator Lalong, I also want to thank you for not dumping the views of one section on us, for allowing Nigerians to partake in the Electoral Act. Senator Bamuru, I'm thanking you on behalf of the minorities. I don't know how many of you are left, but I also want to thank I want to thank Senator Taboa, leave me alone. I want to thank distinguished Senator Opeyemi Bamidele, the leader of the Senate. I want to thank you profusely for this painstaking job that we have done, very voluminous in the interest of our nation. And also thank the clerk of the Senate and the staff of the Senate. And most especially, I want to thank the press, who have remained very stoic and remained committed and still standing, the last people standing. I'm very happy that you have covered this exercise in such a manner that Nigerians see that it is very transparent. So let me just mention the fact that there was no deliberate attempt on the part of the Nigerian Senate to delay the amendment of the Electoral Act. Our intention had always been to ensure that we do our best and we do it painstakingly, taking our time to ensure that what comes out reflects the yearnings and aspirations of all Nigerians. And also to be sure that the next election, all questions connected with the next election will be answered by the amendments to the Electoral Act 2022. So I thank all of you, and I want to now announce of us. We will set up the conference committee, just because definitely I'm sure some of the provisions that we have elicited today will be different from what our colleagues passed and adjourned last week in the House of Representatives. But the social media already is awash with the fact that the Senate has rejected electronic transmission. That is not true. That is not true. Electronic transmission had always been in our act. And what we did was to return the electronic transmission, which had been in our act and which was used in 2022. So please do not allow people to confuse you. If you are in doubt, we will make our final votes and proceedings available to you if you apply, and you are entitled, so that you will see. This Senate, under my watch, has not rejected electronic transmission of results. It's in my interest as a participant in the next election for such to be done. So please don't go with the crowd. Don't go with the crowd. We have retained what was in the previous provision. That's all we did. So if we rejected what was proposed by way of amendment and said, let's retain what was in the previous provision, the previous provision had made allowance, had made provision for electronic transmission. So it is still there as part of our laws. And I think we should be moving forward, not moving backwards. There is no way we can, in this era of electronics, will now be going backwards. So it's important to know that. So the membership of the conference committee that will work assiduously to bring this back for us to give to Mr. President so that within this month we can commence the process of procurement after the president's signature and after the two chambers have okayed the harmonized version after the conference committee. For the Senate Conference Committee, we have the Senator Mohammed Taid Mongudu as chairman. We have from the Northwest, we have the Senator Adamu Aleru. And then we have from the Southeast, we have the Senator Ojusa Kalu. From the North Central, we have the Senator Abba Muru. From the South-South, we have the Senator Asuquo Ekpenyong. From the Northeast, we have the Senator Aminu Iya Abbas. And from the Southwest, we have the Senator Tokumbo Abiru as members of the conference committee. They are to work and bring back the harmonized version as soon as practicable, but within the month. So accordingly, the Senate will now adjourn plenaries to enable us to attend to the 2026 budget. The chairman of appropriation will make available the timetable for the budget defense, ministry by ministry. Have you done that? No, Senator Ndume.
The chairman of the committee is here. You have to put the chairman of the committee because he has for the harmonization, the conference committee. The committee on electoral matters. You have a chairman who represented us in doing this thing, and then you exclude him from the harmonization. What kind of harmonization are you going to do? No, we are telling you about experience. That is how there is a legislative procedure.
That is the procedure.
Yes, you can have the person who did this work is here. And when you want to go and harmonize, how can you harmonize without the person that did the work?
Senator Ningi. Senator Ningi, don't go far now, because you just made a point that the chairman. Okay. You know how I wish there was any reason. How I wish there was any reason to shout. Distinguished colleagues, if there was any need to shout, Senator Asuquo, will you give us the opportunity to finish? We are discussing about Senator Lalong, and you are going for consultation. Senator Lalong, you are hereby included in this committee. Because
Chairman Judiciary.
I am withdrawing from the committee. I'm withdrawing from the committee. Don't talk to me like that. What are you people introducing?
Chairman Judiciary Committee.
Let me withdraw. I beg to withdraw. I'm withdrawing from the committee. I'm withdrawing from the committee.
Where is Asuquo? Senator Lalong. Senator Lalong. Senator Lalong. Senator Lalong. Even when we came here to start this thing, this report, you became ill. Now we are making you chairman of this committee. Don't be ill. Then we are adding Senator Adegbomire as a member to guide you. So we have Senator Ndume, we are not talking about NGOs. We are not talking about NGOs and BBC. If it is BBC outside service, you will be a senior person. But let me explain something to you. Adegbomire is a senior advocate of Nigeria. So Lalong and Adegbomire will be in that committee. Senator Lalong will be the chairman. Those in support of what I've said say aye. And those against say nay. The ayes have it. Accordingly, the Senate is hereby adjourned in terms of plenary to the 24th day of February 2026 for a